Welcome to Family Law A to Z with DBD.
Welcome to Family Law A to Z with DBD, a podcast from the Pennsylvania-based firm Dischell, Bartle, Dooley. This series reflects the collective experience of the firm's family law team, including attorneys Mark Dischell, Elizabeth Billies, and Katie Lynn Daly, who work close together to provide clear, practical guidance on the legal issues that impact your family and your future. I'm LeAnn Lyon, and today we are talking about retirement accounts in Pennsylvania divorce cases and how assets like 401ks, pensions, and IRAs may be handled when a marriage ends. Joining me for this conversation is Elizabeth, aka Liz Billies, a partner at Dischell, Bartle, Dooley. Liz practices all areas of family law and is known for her thoughtful, collaborative approach to divorce, custody, and financial matters. She focuses on helping families navigate transitions efficiently while keeping long-term stability in mind. Liz, it's great to see you again.
Hi, good to see you. Thanks so much for having me.
My pleasure. Liz, how do retirement accounts typically factor into a Pennsylvania divorce?
So for most people, the two biggest assets that they're going to have in their divorce is a house and likely a retirement plan. Most of the retirement plans that we see are 401ks. So those are employer-sponsored retirement plans. There are also IRAs, which are generally going to be opened by the party individually with a financial institution. IRAs can either be a Roth IRA or a traditional IRA. What I see less of now as we are in the year 2026 is pension plans. Those are where you're generally going to see those are teachers, city employees, state employees, federal employees, but not a lot of private organizations are offering pensions anymore. So one of those types of retirement plans separate from your house is probably going to be your largest asset in your divorce. So they factor in very heavily into the distribution of a divorce. They are divisible as marital property, just to level set for the audience. Marital property is anything owned or acquired during the marriage, regardless of how it is titled. And that is very important because generally pension plans, and I say generally really almost 100% of the time, they're never going to be a joint asset. They're always going to be in the name of the employee. If the person who opened it, they're not joint assets like a house would be titled jointly. Retirement plans are going to be individually titled. And so it's really important to emphasize and for the audience at home and for me to remind my clients that just because it's titled in your name, it's going to go into the proverbial marital pot. And so for a lot of people, that is a surprise to them, maybe not so nice surprise, and they're going to go into the assets for division, and they're likely going to be a very large asset into the pot.
So what if that pension is going to be so small? I was a teacher for 5 years,
Yep.
and years ago. By the time I get it, it's going to buy a cup of coffee.
Right.
Does it still have to go into the pot, so to speak?
Correct. Yep. So anything now, it's interesting. So, what we will carve out is, let's take your teacher pension, for example. If that was earned prior to your marriage, there's going to be a portion of that is going to be non-marital. So any asset owned or acquired prior to the marriage, that's a pre-marital asset. However, the increase in value of that during the marriage is marital. So what I see, I'll give you an example. I use a lot of examples with clients. I've had many a client, teachers particularly, who they were, started teaching at, let's say 22, 23. They started, they're in the plan, and then they get married, at 31, and now they're separating at 45. So the portion of the pension that they earned from 23 to 31, that's not marital. We're going to take that out of the pot. The portion that is earned from 31 to 45, that's in. Doesn't matter what size, but that's going to be in. And we can talk about, how we divide up, how we deal with pensions, particularly how we value them. They're valued differently than a 401k or an IRA, but they're going to be in the pot because they were, they increased in value, or they were started during the marriage, depending on what applies, in the case.
Are there cases where something from one of these situations is from before the marriage and yet all of it gets considered marital property?
No. So anything prior to the marriage is going to be out. It's going to be, again, I explain to clients, I think of it as, either a timeline as an example, anything, if the timeline is, your, birth, marriage is a dot on the timeline, anything from prior to the date of marriage on the timeline, that's going to be not part of the assets for discussion. Certainly I've had cases where people have used premarital assets to pay off somebody for their share of the marital assets, but the premarital money is not going in the pot. The law is very clear on that in Pennsylvania, which is a good thing. I mean, you didn't, the idea is that you weren't there helping me, setting up my classroom at 25 and toiling away with the second graders. You shouldn't get to share in that money. I didn't earn it during the marriage. That's the kind of the idea behind it not being included.
So what is a QDRO? And when does it become part? I don't even know what is a QDRO. And when does it become part of a dividing retirement assets in a divorce?
Sure. So a QDRO or a QDROs, I may say them interchangeably. So for you and for the audience, if I say them interchangeably, they mean the same thing. That is shorthand for a qualified domestic relations order. Say that 4 times fast. And so when you have a 401k or a pension, they are what we call ERISA-backed plans. ERISA is a federal law. In order to have them divided, the plan administrator, so for example, let's say you have an IRA with Fidelity. Fidelity is the plan, is the plan administrator. If you have a PSERS, which is the Pennsylvania State Employee Retirement System, and that's the teacher pension, they're the plan administrator, okay? The QDRO or the QDRO is a separate order that the parties sign, and the judge also makes an order of court. So it's an agreement, but it becomes an order signed by a judge that says, you plan, do this. And what's this? Well, this is whatever your property settlement agreement. The property settlement agreement is the thing that is the document, the agreement that says who's going to get what, for lack of a, more sophisticated terminology. So let's say the property settlement agreement says that husband is going to roll over to wife the sum of $40,000 from his Fidelity 401k. Well, we need to tell Fidelity to do that. And we're going to tell them to do that via this QDRO. They will not roll over the money without the QDRO because, again, the federal law with ERISA, they are ERISA-backed plans. They have to have a separate specific order telling them to do that. And so that is something that, we got the agreement signed. Part of the agreement is that their parties are going to, execute a QDRO. We get that signed off once it's prepared. Judge signs it, makes it an order. We send it to the plan executes it. So it's just it's a requirement. The argument over who gets what is really going to be in the property settlement agreement. The QDRO is just effectuating what the parties have ultimately agreed to or what the court has ordered. But it is going to be needed for any pension distributions or allocations and for any 401k allocations. Sometimes with IRAs, and again, you want to do this research or have your attorney do this research. Sometimes IRAs do not require them, because they are not ERISA-backed plans. So they can just, there are other paperwork that you have to complete, but you don't need that special QDRO for IRAs in general. But always check with your plan at the end, particularly towards the end of your divorce case. What do I need here? Making sure whatever we need the other side to sign off of is reflected in the property settlement agreement.
So you just mentioned that the QDRO may or may not need to be used in terms of, you said the IRAs, but are there other differences between how pensions, 401ks, and IRAs tend to be handled differently in divorce matters?
Sure. So there's a yes. The short answer is yes. So pensions are, you look at a pension statement and it's going to give you, sometimes they'll give you a value. It's not really the value of the pension though. Pensions are a future benefit. You sit there at 45. I'm not going to get that pension until, let's say, 65 in general. So is the present value of a future benefit is what we're valuing. And if we are going to pensions, the value that might be on the statement is likely the death benefit value, or it's just what's in your account, but it's not, it's worth generally more than what the statement is going to say. So we need to, if we're going to have to distribute a pension in a divorce case, there's two ways to do that. And this gets a little technical, but not technical in terms of words, but it's technical in terms of methodology or math, let's say. So there is the offset method, or there's the deferred method. So with a pension, if I want to offset it with another retirement asset, let's say the pension has, I have the other side has a 401k that's sizable. I might be able to get a lump sum value of that pension and say, okay, their share is $100,000. I can offset that from what I would be owed, or what the let's say husband and wife. So if wife has the PSERS, husband has the 401k, husband's share of wife's PSERS is $100,000 but husband would owe wife $100,000 from his 401k. We can just say, I'm going to keep my PSERS, wife, husband, you keep your 401k, and we don't need a QDRO. We don't need to do any of that paperwork. That's the offset method, where we're offsetting one person's share in your pension from your share of that person's 401k. Okay, that's the offset method. That only works if there's multiple retirement plans on both, if there's at least two, one each side, and also the values that has to make sense numbers wise. Let's say that there's only the pension. That's the only retirement asset out there. Call it a house and pension case is kind of the shorthand for that. Just got a house and a pension. Easy. Well, husband doesn't have a 401k. We only got wife's PSERS. There's nothing to offset. So we would do the deferred method, which is when wife retires, husband gets a share of what she gets on a monthly basis. And that's going to be effectuated through that QDRO. That is the defer. We're deferring it. Let's say again, she's 45. So we're deferring the distribution until she's 65, because there's no other way to do it. I try to offset if I can, because it keeps it cleaner and it keeps parties, financially untangled from one another faster. They don't have that financial tail for the next, in a way, for the next 20 years. But sometimes the numbers just don't work. And another consideration, it's like a next level consideration, is sometimes clients don't want to do the offset because they want to keep their retirement portfolio diverse. And by doing that, they I'd have to wipe out my 401k or my 403b if we did it that way. And I want to have, some money in a bunch of pots. So sometimes from a financial planning standpoint, they're fine doing the deferred, but I really try to offset if I can, if that's possible. So pensions are pensions are interesting. You cannot take the statements at face value. That's a real important point here. And then also is, okay, can we offset? If so, got to get a lump sum value done by an actuary. If we can't offset, we'll go the deferred route. We need to get that QDRO. 401ks, IRAs, for the most part, you're going to get that you're going to get that statement. That's the value. That's what it is. There's no, that future benefit. That's not a thing that exists in 401ks, just kind of the types of plans they are. So they're a lot easier, but those pensions are, we want to, which is a little extra work has to be done if there's a pension in your divorce.
Well, we may wish that we knew the future value of those, but
Right.
The reality is the reality. We can't see tomorrow. So what kind of mistakes or misunderstandings do you see people make when it comes to their financial assets during divorce?
So one of the things that I think a lot of people forget to think about is taxes and the tax liability. So your house, your bank account, your cars, those are post-tax assets. I have purchased my car with my post-tax income from my job. Okay, I've paid taxes on that money. Retirement accounts are pre-tax income. So you have not paid taxes on that money. The idea is we don't pay taxes now at our higher tax bracket while we're working. And when I withdraw the money at, 70, 75, 65, whatever, my tax bracket is going to be lower because I'm no longer working. So ultimately my taxes will be less on that money. So again, loving an analogy, think of it as apples and oranges. Houses, post-tax assets, apples, pre-tax assets, oranges. You can't mix apples and oranges. They're not worth the same. $1 in my bank account is not worth $1 in my 401k. My 401k has not been taxed yet. And so people try to offset cash and houses with pension monies or 401k monies without taking that into those future taxes into consideration. And you're not getting the right amount. The math isn't mathing, as the kids say. So we want to that is the number one thing that I see. And I'm always, I'm not a tax lawyer, but I play, I joke, I play one on CV. Like I have to spend a lot of time with taxes because these are considerations. And if it's a very large rollover, like you could be losing your client $10,000, $20,000, $30,000 by not taking these taxes into consideration. So I try to keep cash assets with cash assets, tax, and then, retirement with retirement if possible, because it makes it cleaner on the taxes. That's probably the one thing I see the most. And then also that thing I was talking about before with the pensions is, well, my pension's worth $25,000. That's what this statement says. Like, oh, it's not. It's worth way more than that. And so not recognizing that and not looking behind and saying, okay, do I need to get a valuation here? Like not going behind the curtain for that. That's probably your second mistake that I see the most.
So I know that you are both an attorney and a mediator, which adds a little flavor in here. So just briefly, as a final question here today, explain how mediation can benefit a couple with regards to their financials in a divorce.
Sure. I think one of the benefits of mediation is the ability to be creative in your resolution. The court system, they don't have a responsibility to be creative. They want to get the case done. They want to get you completed and out the court system. And that's a honorable goal. And that is that's a goal that they should have. In a mediation, because I'm able to sit down with the parties and have like face-to-face conversations, which, the litigation, a courtroom is not the place to have a face-to-face like conversation. It's to litigate. We can be creative and also really speak to what are the goals of the parties. I really want to keep more of my retirement. I really want to stay in the house. I'm good on I don't need as much retirement because I'm 35 and I know I'm going to, work for the next 30 years and make more. So we can keep those goals in mind. We can have conversations. We can be creative. I can show them the numbers. We can talk about the taxes, the tax considerations. It's ability to have a conversation and try to come up with a resolution that everyone can live with. That's always the goal of mediation. No one's going to 100% get what they want, but when you have assets that you need to help understand, a conversation is always going to let you do that. And the court system, they're just not always going to be able to provide you with that time to have that conversation.
Wonderful. Well, I'm glad we got to sneak that in here today. And for our audience, that is it for today's episode of Family Law A to Z with DBD. If you'd like to learn more about Liz Billies or the family law team at Dischell, Bartle, Dooley, visit dbdlaw.com. There you will find resources and information about divorce, equitable distribution, and other Pennsylvania family law matters. Thanks for listening, and remember to like, subscribe to the show, and leave a review if you found this episode especially helpful. Thank you, Liz.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.